It's quite important to Singapore. We've got a lot of R&D centers by major pharmaceutical companies and clinical trial centers as well, and that's increasing. The number of patent publications in the pharma industry has gone up from about 5% in 2005 to about 23% in 2017. So you can see how, pharma industry, it does play a big role to Singapore. So just like the UK and the former EP, UK Patents Act Section 2, 1977, so this is before the amendment that they had. Likewise, the EPC prior to the 2000 amendment. We have a provision in the Act which supports first medical use claims. So basically, I've reproduced this section for you. I'm not going to read it. But basically, this, like I mentioned, this is the legal basis for first medical use claims, of which the format is compound X for use in medicine, or compound X for use in the treatment of disease Y. So even if you specify which disease the compound is used for, if you put your claim in this format, the Singapore Patent Office recognizes this as a first medical use claim and not as a second medical use claim. We also have, Section 14 relates to the novelty provision, and Section 16 relates to the industrial applicability provision. So again, Section 16, 2 and 3 of the Singapore Patents Act is similar to the UK Patents Act, Section 4, prior to the amendment that they had. And this kind of just provides, further basis for first medical use claims. So you might ask, what about second medical use claims? Now the thing is, there is no basis, no legal basis in the Patents Act for a second medical use claim. That's because Singapore has not amended its legislation following EPC 2000, which, the UK followed. And although the Singapore Patent Act is based very largely on the UK Patents Act, like I mentioned, we have not actually amended the Act following EPC 2000. So currently there is no provision in the Patents Act for a second medical use claim, but we still recognize the Swiss-style format, and this is historically based on the UK case law and European case law. So the examination guidelines make it very clear that only this format and this format only will be accepted for recognizing second medical use of any compound, second or subsequent medical use. So that's the use of compound X in the manufacture of a medicament for treating disease Y. So I'll leave it at that for the time being, and I'm going to go through very quickly how the Singapore system has evolved. There's a reason why I'm doing this, and it will be clearer in my next few slides. So from 1965 was when Singapore gained independence, and at that time we didn't actually have a Patents Act, and we had the re-registration system. So as long as you had a UK patent or a European patent, you could actually get that re-registered and automatically get protection in Singapore. In 1995, that's when our Patents Act was enacted, and it was based on a self-assessment system. So what that meant was that you could actually get a Singapore patent based on a negative examination report. So it was basically, the onus was on the applicant to ensure that your claims were patentable prior to paying the grant fee. But of course, there were cases where you could have a negative examination report and the applicant could pay the grant fee and you'd still get a Singapore patent. In 2014, now that's when we had our major amendment. 14 February was the date, very apt date. And basically, we switched to the positive grant system, where you could only get a patent granted in Singapore if you had a notice of eligibility, similar to your Communication 71.3 for EP, and a notice of allowance from the US. So at least that gave some certainty to third parties that, okay, this patent is valid. In 2017, we had one more round of amendments, but this was nothing to do with the major change was more for the novelty perspective of the introduction of the grace period. But in 2020, which is coming up, 1st January 2020 to be specific, we're actually going to be closing our foreign route. Now, I think many of you use that route, and my next slide is going to give you more information on that. But come 1st January 2020, all applications will have to go through local examination in Singapore. So currently, the options that we have for requesting examination is that we've got the local search and examination route, we've got the mixed route, which basically means that you could use your ISR or a search report from a corresponding patent application, and you could then request local examination based on that search. So there is some cost saving because you save on your search fees and you just pay the examination fees. And the third one that we have, which is the one that's going to be abolished, is what we call the foreign route, in which you request supplementary examination, and it's more or less a formalities examination, because what you do is that you rely wholly on a corresponding application or the IPRP that has a corresponding application that has been allowed, or the IPRP, and you just amend your claims to conform to that foreign application, and you request supplementary examination, and the patent more or less goes through to grant. However, like I mentioned, that's going away 1st January 2020. Now, the good thing about supplementary examination is that it's cheap and it's fast. However, there is a condition of relatedness that you have to satisfy before you request supplementary examination. So the most straightforward way would be for you to amend your claims to conform to the corresponding application. Now, what happens when you have second medical use claims or Swiss style claims? If the patent that you're relying on has second medical use claims, then there's no issues. However, let's take, for example, the US application that you want to rely on. In the US, it's method of treatment claims. And method of treatment claims, as we saw earlier, under industrial applicability, they're not considered to be patentable. So what then? Can I use my US granted patent to request modified examination in Singapore? Unfortunately not. Because if you recast a method of treatment claim into the Swiss style format, you do not satisfy the condition of relatedness. So you will not be able to request supplementary examination. Likewise, for the new the EPC 2000 format, which is what Marcus touched upon earlier, the compound for use claim, it's when you change that into a Swiss style format, unfortunately, the Patent Office does not see that as being equivalent, and they see that as not satisfying the relatedness requirement. So basically, you can't use any of your major jurisdiction patents for getting an allowance in Singapore based on supplementary, the cheap route, I would say. So you have no choice. But when you need protection in Singapore for second medical use claims, unfortunately, you have to request local examination. So if you recast a method of treatment claim into a second medical use claim, that's okay, provided you request local examination and not supplementary examination. So for that reason, I think, the abolishment of the supplementary examination route for pharma companies who have patents with second medical use claims is not going to make much of a difference, but perhaps in other industries it may. So I'm just going to quickly touch upon a recent case that we had in Singapore relating to, which talked about second medical use claims. We were all very excited about it because it was the very first case that touched upon second medical use claims. Fortunately or unfortunately, it didn't quite talk talk about enforcement of second medical use claims the way we wanted to see guidance from the courts. But there were some interesting comments that were made. So just to give you some background about the case, I mean, again, this is to do with the pregabalin as well. I think that case, that was litigated in many, many countries. Singapore was no exception. So Warner Lambert was the holder of the patent. What Novartis was doing was they were applying for a product license to market the generic pregabalin in Singapore. Now, in Singapore, when you request for, or when you're applying for market authorization, we have patent linkage. So the applicant of the product license has to inform the patentee that they're applying for this product license, and that they, with the declaration that they're not going to be infringing the patent. So that's what Novartis did. They informed Warner Lambert of its product license application and said that we will not be infringing your patent. Now, what Warner Lambert did was they commenced an action that to say that the product would indeed infringe their patent. Novartis then counterclaimed for revocation of the patent and said that, well, your patent's invalid because the only claims that your patent has are method of treatment claims. Now, going back to where I talked about the history, Warner Lambert actually got their patent in Singapore under the self-assessment system. So Novartis was right. All their claims were method of treatment claims, and method of treatment claims are not patentable in Singapore, but they still had a Singapore patent. So that's when Warner Lambert realized, ooh, yeah, we're in trouble. So what they tried to do was they sought for permission to request post-grant amendments, and once infringement proceedings have commenced, you have to seek permission before the court. So then there was a separate trial that took place as to whether or not the court should allow leave to Warner Lambert to amend their claims. Basically, what they were going to do was to recast their method of treatment claims into second medical use claims. And basically, the High Court dismissed their application for post-grant amendment on the basis, well, the main basis was that there was an undue delay on the part of the patentee in requesting this post-grant amendment. But what happened was, because, like I said, everyone was very excited that this was the first time we were dealing with method of treatment and second medical use claims in court, the High Court actually talked a little bit, went beyond just talking about the undue delay issue and talked about whether or not this recasting of method of treatment claims into Swiss-style claims, would that be considered as adding matter, and whether that would extend the scope of protection post-grant. Now, the reason they talked about these two specific issues is because for post-grant amendment in Singapore, just like the UK, you cannot add matter. I mean, you can't add matter anyway for whether it's pre-grant or post-grant. But at the same time, for post-grant amendments, you cannot extend the scope of protection beyond the scope that you were conferred at the time that the patent was granted. So on the first issue of whether there was any added matter when you do this recasting, the High Court ruled that there was no addition of matter when you did this recasting. And the reason they gave was because both types of claims, the method of treatment as well as the Swiss-style claim, but implicitly involved a step of manufacturing a medicament. So the Swiss claim would include a manufacturing step, and the method of treatment claim would require the medicament to exist. So therefore, the manufacturer of it was unambiguously disclosed. So this was good news for us, because we advise clients many times, especially before they request local examination, that you need to recast your claim. So it was good to know that recasting, whether it's pre-grant or post-grant, did not add matter to the application. The second issue, like I mentioned, was whether the scope of protection was being extended by this recasting. And the High Court ruled that yes, there was an extension of scope of protection. So the Swiss claim covers the making of the compound for administration purposes. And a method or treatment claim only covers the follow-on act of administration of the compound. The patent, which was originally based on method of treatment claims, therefore only covered the administration of the compound for treating pain and not the preceding manufacturing process that produced the compound for that use. So therefore, administration of the compound in a treatment did not cover the use of the compound in the manufacture of a medicament, and therefore there would inevitably be an extension of scope. So for that reason, that was another reason why they did not allow the post-grant amendment. However, just the take-home message of this was that it's pre-grant amendments should be no issues because scope of protection is not an issue pre-grant. But like I mentioned, it's good to know that the court has decided that when you recast claims, it does not add matter. So this was good news for us. Well, obviously, Warner Lambert was not very happy with the decision, and they went on to appeal the decision before the Court of Appeal. Unfortunately, the Court of Appeal dismissed the appeal and said, no, we totally agree with the High Court's decision. But what was interesting that came out from the Court of Appeal decision was some comments that were made by the judges. Now, the other thing that was very special about this Court of Appeal decision was, the Court of Appeal case, was that generally in our Court of Appeal, we only have 3 judges that sit on the bench. But for this particular case, they decided to have 5 judges, and they only do that for very important cases. So you can see again that there must be some push for us to, for there to place some importance in this decision, because like I mentioned, it was sort of like a landmark decision for us. Now, in the Court of Appeal decision, what the judges mentioned was that the UK has made legislative changes to recognize second medical use claims in the form of purpose-limited product claims. And that format was also shown by Marcus as being substance X for use in treating disease Y. However, no amendments were made to the Singapore Act. Now, Section 14, what the judges said was that if you look at Section 14.7, and I've reproduced that again here, if you look at it closely, you could argue that it seems to support the patentability of second and subsequent use of known compounds, because by its ordinary meaning, it does protect any use which is not part of the state of the art. And because of that wording, the part that I've underlined, they said, by virtue of this interpretation, Section 14.7 may support patenting of second medical and subsequent uses of known compounds, and a purpose-limited product claim, like in the UK or EP, may therefore suffice. So, and they said that if this, if we were to adopt this approach, we will not require Swiss-style format second medical use claims anymore, and we could actually switch to the purpose-limited type of claim, similar to the UK or the US, UK or EP. And that was really interesting because soon after that decision, the Court of Appeal decision came out, our patent office actually issued a guideline saying that, as of now, it's status quo. Please continue filing applications with Swiss-style format claims only and not purpose-limited claims. However, from the practical side of things, what we are advising clients is if you don't want to put a purpose-limited claim in your claim set, but at least have some sort of wording in your description that has the EP wording, so that, should the Singapore Patent Office change its practice in view of the interpretation suggested by the judges, you have basis for that kind of claim. Unfortunately, I'm running out of time. What I wanted to touch on was patenting in the ASEAN region. But what my point was going to say, I'm just going to quickly summarize what I was going to say. So in the ASEAN region, these are the countries that make up ASEAN. And most of the countries have very slow patent prosecution system, very slow examination in those countries. What you could do is you could actually, I know that a lot of pharma companies have set up manufacturing activities in Thailand, Indonesia, and Vietnam, and you obviously want to get patents there. So one way is actually to make use of ASPEC. Now the laws in most of the ASEAN countries is actually this almost similar to Singapore's law where second medical use claims are concerned. So they too all recognize Swiss style format claims for second medical use claims. So what you could do is you could try and get a patent granted in Singapore, because it's really quick to get a patent in Singapore given our very efficient system that we're very proud of. And you can then use the Singapore grant to try and expedite your examination in the other ASEAN countries by requesting ASPEC. And ASPEC works very similarly to PPH. So that's just something that I wanted to suggest, because I know that a lot of pharma companies have set up manufacturing facilities in the ASEAN region. So with that, thank you very much for your attention, and apologies again for how I sound. Thank you.